By purporting to re-sentence Mr. Clanton under today's law and finding that Mr. Clanton under today's law would be sentenced as a Class A felon without articulating any reasons for it. And under the statute 3917-417H, the judge is supposed to re-sentence you. He's supposed to re-sentence you under modern law, under the law of today, and I guess that's what the judge purported to do, but he didn't give any reason for why under today's law it would be a Class A felony as opposed to only a Class B. Under law at the time, it had to be a Class A, but under modern law, which is sort of confusing and I submit poorly written, it can be either one. And the problem with the statute under today's law is that it can be either one, and it doesn't, nowhere in the law seems to give the judge any criteria under which to decide whether it should be a Class A felony versus a Class B. But in any event, here the judge did not give any reasons for enhancing the sentence to a Class A, and so I've submitted that the judge both violated due process in doing so.
Well, and let's back up. So first of all, your client was already convicted of a Class A, correct?
Yes, sir.
And so under the new law, the judge can, if petitioned, can look at the new law and say, hey, under the new law, I can take away the drug-free school zone, I can drop it to a B, those types of things, correct? I can take the 100% away and I can drop it to a B, correct?
Basically, except I would phrase it more that he has to re-sentence you de novo and decide.
Where do you see that in the statute?
Well, I mean, just the word re-sentence, I wouldn't phrase it in terms of dropping things. I would phrase it in terms of...
It's the way I've seen it interpreted is it's a review of a sentence from somebody who was convicted of the old statute. Now there's a new statute. And so what we've said is you can review this old sentence under the guise of the new statute, and you can revise the sentence how you see fit as a trial judge. And so here, your client was convicted under the school drug-free school zone. He was within 500 feet, which is what the new statute says.
Right.
So that would still be an A. But what the trial judge here did was say, but I'm going to take away the 100%, but I'm going to still leave you at an A because you're still within 500 feet, which is what the new statute says, correct?
Yes, Your Honor.
So how is that a violation of the statute then?
Well, what I would submit is that Mr. Clanton is placed in the same situation he's supposed to be placed in the same situation he would be placed in if he committed the crime today.
Okay, so he was within 500 feet of a school, so that's an A.
Right, and if he committed the crime today, then the judge could classify it either as a Class B or as a Class A. And I'm submitting if he's going to increase it to a Class A as opposed to a Class B, he's got to have some reason articulated for doing so.
He didn't increase it.
He didn't increase it.
I mean, it was already set based on a jury finding.
Well, the jury finding could have it be either a Class B or a Class A, and for him to pick one over the other, he needs to have some reason.
Not at the time of the judgment, though. At the time of the original judgment, it was a mandatory A felony. Excuse me.
Correct.
I get choked up when I talk about these.
It was at the time of the judgment, but under this statute 417H, the judge is supposed to do a two-step analysis. One, he's supposed to say, how would the defendant be sentenced if he committed the crime today? That's step one. And then step two, if that new sentence is lower than what it was originally, then I'm supposed to look at whether the interests of justice allow for it.
So if that crime was committed today, and your client was within 500 feet of a school, he's going to get an A.
Well,
but what the trial judge did was he gave him the benefit, when you talk about the lesser of the two sentences, is he took away the 100% and gave him an A at 30%.
But that's what I'm saying, Your Honor, is he's not going to get an A. Under the statute, he can get either a B or an A, and it's supposed to be up to the judge to decide which one is correct. Here, the judge didn't ever really even say which one is correct. He certainly didn't articulate any reasons for why an A was correct over a B. And so under various cases, including State versus Lewis, State versus Dagnan, and State versus Buys, a sentencing court is supposed to, an exercise of discretion is supposed to be based on the proper legal principles, and the judge is supposed to articulate those legal principles. Here, the judge came right out and admitted that my reading of the statute is correct, that there are no legal principles to apply. And in any event, he didn't apply any legal principles. And so I'm just submitting that is an abuse of discretion as the courts have defined it. And more than that, it's a violation of due process to have a sentencing law where the judge can just make a sentence without any reason at all. It allows for, it's a vague, unconstitutional law because it allows for arbitrary enforcement, discriminatory enforcement by judges, policemen, etc.
What about the general purposes and principles of the Sentencing Reform Act? Wouldn't those also apply to sentencing decisions under this section?
Conceivably, but again, the judge didn't articulate any of those, and so even if that's the case, I would submit he still abused his discretion.
I'm speaking more to your constitutional argument regarding the statute.
I mean, those principles are so vague. I guess if we said that, you know, if the judge said, I find because the general principle of deterrence or incapacitation or whatever requires this to be an A as opposed to a B, then maybe that would save it from a due process challenge. Ultimately here, the judge didn't find that, and instead the judge specifically agreed with me that nothing in the sentencing code helps you decide whether to make it an A versus a B.
We were talking about consecutive sentences earlier, so let's go back to 4035-115. That gives the trial courts permissive discretion to impose consecutive sentences, but doesn't say when and under what circumstances that should happen. Is that statute likewise unconstitutionally vague?
I mean, I don't really think so, because one, that statute does lay out 3 or 4 different times when you can be eligible for consecutive sentencing. And in addition to that, this court is clear.
Oh, it tells you when you can get consecutive sentencing, just the same as this statute tells you when you can get a classification enhancement. But what it doesn't say is on what basis the trial judge should make that discretionary decision.
That is true. However, different decisions of this court over the years have clarified that the judge is supposed to include other factors in his consideration too, most notably whether the collective sentence is reasonably related to the seriousness of the offense. And so I would just submit, if the judge is bound by that constraint as well, then that would eliminate any vagueness or due process challenge to consecutive
Well,
sentences.
that just applies if you're relying solely on the dangerous offender enhancer. I don't believe that applies to any of the other enhancements.
I found cases, and I don't think I cited them in this brief because it wasn't really a topic we were arguing over, but I found cases where it was applied for things other than just the dangerous offender, where it was applied for the substantial criminal history and other things. And I think professional criminal also. But in any event, you know, under Townsend versus Burke, which is a United States Supreme Court case, sentencing has to require under due process, it has to require a scrupulous and diligent search for truth. And under Chapman versus United States, another United States Supreme Court case, they basically came right out and either said or at least implied that a sentencing cannot be arbitrary, that would contravene due process. And that was a case where they were talking about whether a sentencing guideline was arbitrary or whether it has any rational basis for enhancing an LSD sentence under certain circumstances. And ultimately, in that case, they found that it did have a rational basis, and therefore it wasn't arbitrary, and it didn't violate due process. But in this case, the judge did not articulate any reasons at all. He seemed to agree with me that the statutes don't provide for any reasons at all, and so therefore I contend that this sentence, either this particular sentence violated due process, or if you want to go further, we could say that the new sentencing provision more generally violates due process. Either way, Mr. Clanton should get relief.
What would that relief be if this statute were declared unconstitutional, or at least unconstitutional as applied to your client? Wouldn't we just reimpose the original judgments that were imposed by the jury, which would include 15 years at 100%?
What it would be is there's a separate statute that talks about how you're basically supposed to presume that the legislature meant each different part of a law independently unless there's some good reason to hold otherwise. And so, no, Your Honor, I would say that the new law of allowing it to be a class, of allowing the judge to make it a Class A, that part is unconstitutional, but the remainder of the sentence is, the remainder of the law is valid. So in other words, the sentencing review procedure is still
But
valid.
the part that allows it to be an A is the same part that allows it to be a B. So, I mean, for you to say, we just cut out these 3 words and therefore we cure the problem, I mean, the statute is, you can either make it an A, you can make it an A or you can make it a B. And then subsequent. So to Judge Hickson's question, to give you what you want, we have to just say, you can't make it an A or a B, which means we'd have to go back to the original sentence, oversimplification, but that's really what you're asking us to do.
I don't have the statute right in front of me, and I'm trying to remember exactly how it's set up, but my understanding is that they repealed the part that says, in essence, it shall be an A, and then they implemented a new section that said it may be an A, and I'm just contending that they clearly meant to obliterate the shall part, and if the new part saying it may be upgraded to an A is unconstitutional, then that just means it's got to be a B and can't be an A. In any event, if the judge...
Well, my next question is, did you challenge the constitutionality of the statute in the court below?
Yes, Your Honor.
The court's comments seem to suggest you did not.
The court's comment, as best I can recall, the judge didn't very squarely even address my constitutional argument, except to just say that I was right, that the law doesn't seem to require any criteria for magnifying it to an A. I don't think he really commented, as best I can remember, exactly on why he was not finding it unconstitutionally vague. I just know he didn't ultimately find it unconstitutionally vague, and he implemented it as a Class A, again, without really articulating any reason why.
So also the statute says the trial court may choose to resentence, correct?
Yes, Your Honor.
So what if the trial court chooses not to resentence?
He's allowed to do that.
Okay, so he can arbitrarily decide not to do it, but your argument is once he says I'm resentencing, he has to start all over?
If you look at the order of operations laid out in the statute, he starts all over on the front end saying, if I were doing this today, this is what the sentence would have been if you committed this crime yesterday. And then once he's got that set in stone of what the other sentence would be, then he's supposed to look at the interests of justice and say, do the interests of justice forbid or preclude me from going ahead and doing that? And if not, then he's supposed to go ahead and do that. And so I just submit that he shouldn't really be anchored in his mind or otherwise to what the original sentence was. He's supposed to just look at what would it be today if you committed the crime yesterday. If there are no further questions, I will come back for rebuttal.
Good morning, Your Honors. May it please the court. Garrett Ward here on behalf of the state of Tennessee. Your Honors, this case is sort of the latest in what's now become an increasingly long line of cases dealing with the effects of the amendments to the Drug-Free Zone Act, and then the specific inclusion of subsection H, or the resentencing provision.
What would his sentence be if he were sentenced today for the crime he committed? What would his sentence be today?
The sentence that he's currently got, Your Honor, without, if at the risk of being too flippant with the court, that's precisely what he would receive. And I'll elaborate briefly and explain to the court exactly what happened in the initial crime, because that's obviously relevant to what his sentence would be today, and then what the trial court did here, because I think it's, with respect to Mr. Justice, I think it's a good deal more than essentially placing no reasons on the record. Your Honors, the defendant in around about 2015 was convicted of sort of a grab bag of drug-related offenses. The relevant one for the purposes of this appeal is, I believe it's count 9 of his original indictment, is a drug-free zone count. Stems from a controlled by. The defendant and a confidential informant arrange a controlled by, and at the defendant's suggestion, this controlled buy for methamphetamine occurs at a mobile home park that the confidential informant is living at. This mobile home park is 300 feet from the boundaries of, I believe it's a Bedford County elementary school. So that's what happened below. That's the crime relevant here. And then the trial court looks at those facts and essentially makes two findings which are highly relevant for what the trial court needs to do in terms of resentencing. One, it rightly notes that 300 is less than 500, so within the reduced radius of drug-free zones. The 2020 amendments, I believe, reduced it from 1,000 feet to 500 feet. So the defendant's conduct still falls within this reduced radius. That's the first finding. And the second finding is the court looks at this rebuttable presumption that, and the statute's a little confusingly worded here, so my apologies if I quote it wrong. The statute says that there's a rebuttable presumption that a defendant is not required to serve at least the minimum sort of 100% day for day. And that rebuttable presumption can be overcome if the state shows that this particular drug transaction exposed vulnerable persons to the dangers inherent in the drug trade. And the court says, well, while it's the case that this is within the 500-foot radius, the state hasn't sort of overcome this rebuttable presumption. It points to a couple of things. School, I believe, was not in session at the time. I think the Bedford County Custom has school out for about 10 days around Labor Day. Due to a walking horse competition is what the trial court places on the record here. So the court says, essentially this sort of heightened release eligibility, that doesn't apply here. But this is within 500 feet, so this can properly be elevated to an A felony. So he leaves the sort of number of years, 23.5, leaves it as is, lowers the release eligibility. It's the same sentence he'd get today. And really, Your Honors, I think that is this case in a nutshell, is the trial court did exactly what the Sentencing Act asks for it to do, exactly what the Resentencing Act, or the resentencing provisions of the Drug-Free Zone Act ask for it to do, and imposed a sentence that recognizes the seriousness of committing drug offenses so close to schools, but does not sort of impose an overly onerous sentence based on the sort of more remote nature of this specific transactions to the people who might have been in those schools. So the court does specifically note when it's making this sentence that sort of hits on a couple of times how close this actually was to the grounds of the school. I believe at some point the court says that in their sort of path, the defendants and the confidential informants in their path to get to this park, they essentially go like right in front of the school. So the court is concerned about just how close this transaction is to the school. That's why it elevates it to an A, and that's precisely what it's supposed to do under the Sentencing Act. So as for the sentence itself, well, I'll address the constitutional challenge in a minute. As for the sentence itself, it is undoubtedly appropriate. This is exactly what trial courts are supposed to do in these sort of Section H cases. They are supposed to examine the facts, examine the law, and render a decision based on the principles of the Drug-Free Zone Act, which are laid out in the first subsection of 432. And then Judge Hickson, you mentioned earlier, as with any sentencing case, the purposes and principles of the entire Sentencing Act are at play here as well. So the trial court renders that decision in accordance with these principles. As for the constitutional challenge, I understand there to essentially be a vagueness challenge being raised to not the resentencing provision of the statute. I believe, if I understand the defendant's position, he thinks subsection H is constitutional, but then thinks that the extant portion of the Drug-Free Zone Act's sort of base sentencing provision, that is vague. And just to clear up for the court, precisely what the the Drug-Free Zone sentencing provision says is, and if certain circumstances are met, an offense may be punished one classification higher. Your Honors, I think it's relatively obvious from the statute that the main principle governing whether or not a drug offense should be punished one classification higher is it occurring within the sort of 500-foot forbidden zone laid down in the statute. That's sort of our main guiding principle. The statute explains very clearly when an offense may be elevated to an A. There's no serious argument can be had on that point. I take defendants' vagueness challenge to this statute that frankly to me seems relatively clear to be, well, perhaps we in 432 just don't say quite enough about when an offense may be elevated. And Your Honors, I think the problem with this approach is it's dangerously close to equating discretion with vagueness.
Was the original Drug-Free School Zone Act, which was worded very similar to the subsequent ones, obviously with tweaks that, was it ever found unconstitutional for vagueness?
Not to my knowledge, Your Honor. And I think the reason for that is the Drug-Free Zone Act sets out quite clearly what it is prohibiting.
Can it be, I'm with you, there seems to be kind of a dual argument on the constitutionality. He seems to make a general, it's just unconstitutional. There also seems to be an underlying, well, it's unconstitutional as applied to me. How do you respond to the as applied to this defendant?
As the as applied challenge, to the extent there is an as applied challenge being raised in this case, I think it fails at the first hurdle, because if there is any defendant who this act would clearly apply to, it would be Mr. Clanton, because of the clear proximity of his transaction to the school in this case. It's not, there's no question that he's within the zone that is forbidden by the statute to be trafficking in narcotics. There's no dispute in the record about that. 300 is quite clearly less than 500, and I think that about ends, to the extent there is an as applied challenge to that portion of the statute, that about ends it. I think defendant's larger argument is just, well, the statute says may. Judge Hickson, you asked a question about trying to differentiate this from, I believe it was the consecutive sentencing provisions elsewhere in the Sentencing Act. The consecutive sentencing provisions are far from the only other example in Tennessee's sentencing scheme where trial courts are called on to make discretionary decisions. A long line of cases from this court and the Tennessee Supreme Court has said, and the Sentencing Act itself has said, in making these decisions, courts have to keep the purposes and principles of the Sentencing Act in mind. And those principles have been enough to pass constitutional muster in every case.
What do you make of Mr. Justice's argument, though, which I think all of this is kind of premised on. He is asking us to not view the imposed sentence as the starting point. He's asking us to view as the starting point what would have been basically the Class B sentence had he been convicted today. What is the correct starting point, and how does that dictate the outcome?
I mean, Your Honors, the correct starting point is the existing sentence, the sentence from 2015. And to support that, I'd point the court to subsection H. What subsection H sort of contemplates a court doing is starting from this initial sentence and then looking at, well, if we were to start over from today, might that be less? If so, do the interest of justice weigh in favor of imposing a new sentence? But the clear starting point, because there's this initial hurdle that the defendant has to overcome to show that if we were to be starting all over, he would be able to receive a lesser sentence. The clear starting point for that is the original sentence. That's the baseline against which the new sentence is to be sort of evaluated in terms of its length and severity. So I don't think we can just sort of ignore the fact that we do have this 2015 conviction with these jury findings as an A-level felony. That's the crime the defendant was convicted of in 2015, and the General Assembly saw fit in 2022 to give the defendant an ability to sort of reduce his sentence. But the General Assembly didn't sort of write the statute and sponge away his initial conviction. Subsection H starts with the sentence that exists, and then the trial court moves from there. So we can't ignore the fact that he was initially convicted of an A felony, and I think that's something that is just sort of bubbling under the surface of this case that is just a little strange. The defendant here didn't receive an enhanced sentence by this trial court at the resentencing stage. He received a reduced sentence. He's suggesting the trial court needed to reduce his sentence more. And I think what this sort of odd position is, Your Honors, this, in some ways what's happening here seems sort of more similar to a collateral attack than a direct appeal. It's a little unclear at times if we're attacking the constitutionality of the resentencing provisions of the current, or the sentencing provisions of the current Drug-Free Zone Act, which the defendant was not sentenced under. Or are we maybe attacking the constitutionality just of the resentencing provision, and then it's sort of looping in the current version of the Drug-Free Zone Act sentencing scheme, or maybe this is an attack on the original Drug-Free Zone Act sentencing scheme itself. It's a little unclear as I've laid it out for the court as best I understand it, as a vagueness challenge to a sentencing provision that the defendant was not ever sentenced under, that is relevant because he was resentenced under subsection H. And really, Your Honors, what that seems like is some sort of collateral attack on his original sentence rather than an appeal from the trial court's resentencing determination. In this case, we know from State versus Watson that if a court grants a new sentence under or reduces a sentence under the resentencing provisions of the Drug-Free Zone Act, that there is an appeal that flows from that. And to some extent, we have discussed that in this case. You know, I take the defendant to be saying, as defendants are in many sentencing cases, that the trial court just didn't say enough. Your Honors, as to sort of the base, the core of this case, as I've explained to this court, I disagree. The trial court, I believe, enters about a 14-page sentencing order from 266 to 278 of Volume 2 of the technical record. Is an extensive sentencing order, That's really what this appeal is most properly about. These constitutional challenges to various portions of the Drug-Free Zone Act. Your Honor, I believe they are meritless and are in some respects more similar in nature to collateral attacks than to a direct appeal from the sentence that was actually imposed in this case. I want to briefly address the sort of waiver question of these constitutional challenges in the first place, since the court inquired about it. What the trial court says here, the trial court doesn't ignore the constitutional arguments. The trial court says, and this is on page 278 of the technical of volume 2 of the technical record, the trial court says, although the defendant attacks the constitutionality of the act, he does not ask me to render a ruling on its constitutionality.
What does that mean?
That's an excellent question, Your Honor. And I think really the trial court is maybe at the same place that I'm at, and maybe at the same place that this court is at, and that it's not entirely clear which portions of what statute are being attacked on what grounds. The trial court understands that the defendant is making some sort of constitutional claim, but he doesn't want to throw out the entire resentencing statute because then he'd be stuck with 23 years at 100%. So he doesn't, so the trial court is sort of recognizing that there have been constitutional principles discussed. The trial court interpreted Mr. Clanton's actions below as actually asking the trial court to not rule on the constitutionality of the act. To the extent this court interprets the record below in the same way that the trial court did, I believe a finding of waiver as to the constitutional claims would be perfectly acceptable. The state's also fine for this court to rule on the merits of the, I guess, the vagueness challenge that I've identified.
Well, back to Judge Hickson's question. I mean, we'll play on words, but the vagueness of the constitutional challenge, how do we piecemeal that? And aren't we really just at the end of the day, if we give him relief, just reimposing the original sentence? 23 and a half at 100%?
From my perspective, Your Honors, I believe that's what you'd have to do.
Based on the arguments been made, how do we pick apart the statute? And I think that's what the trial judge was trying to say.
I think that's right, Your Honor.
Is that you raise these terms, constitutional terms, vagueness, this, that, and the other, but you don't explain to me what your specific challenge is, and without that, I can't really rule on it. Is that? I mean, that's how I'm reading that comment, as weird as it is.
I think that's essentially what the trial court is saying, is that there are constitutional principles that are certainly out there in the ether in this case that are being discussed. There's not, at least from the trial court's perspective, a specific ask. The trial court rightfully recognizes that the defendant would not be served by throwing out the constitutionality of subsection H, or of the entire drug-free, if the court declares the entire Drug-Free Zone Act unconstitutional, the defendant is in the exact same place he would have been otherwise.
But he's asking for severability here today, and says that the vague part is the discretionary upgrade to a Class A. So if you cut out that vague part, you're left with a Class B. What do you say to that?
So two points on that, Your Honors. One, I do think it's important that the sort of term Class A and Class B, those don't actually appear in the Drug-Free Zone Act itself. The Drug-Free Zone Act only talks about
classification higher,
raising it one classification higher. So it's not as if there is some Class B part of the Drug-Free Zone Act that could be left behind. I do understand the defendant to be saying that you can sever out portions of this statute, and the state certainly recognizes that. The severability doctrine is alive and well in Tennessee and is employed by courts all the time. But in this case, what the defendant is asking, is saying should be severed out, is really the heart and soul of the Drug-Free Zone Act. Sort of axiomatic and key to the severability doctrine is you can only do it if doing so doesn't do violence to the act at large. Severing out the portion of the Drug-Free Zone Act that says if you engage in the trafficking of narcotics in a drug-free zone can be punished one classification higher, that is the act. That's the whole thing. That's the sort of the key of the act. So I don't think here that that this court can sever this statute in the way that the defendant is asking.
Because if you sever that sentence out, then there's nothing to sentence. I mean, there's not another alternative.
That's my read of the statute, Your Honor, and my read of the argument. That what the defendant is trying to remove is really the engine that makes the act move. Severability is not meant to be deployed in these circumstances.
What about the service percentage? You could still have the service percentage portion, couldn't you?
You could have the service percentage portion, Your Honor, but I think really when we're looking at the act, the service percentage proportion is phrased in terms of this. There is this rebuttable presumption that you don't have to serve a certain a certain portion, the mandatory minimum for your range. That is certainly a valuable and important part of the statute, but it clearly is on the coattails of the portion of the statute that sets the higher punishment. I believe the introductory provision of the Drug-Free Zone Act talks about we're doing all of this because we recognize that trafficking in narcotics this close to schools and daycares and parks is dangerous and is dangerous to society and is undesirable conduct. And then the first thing that the Drug-Free Zone Act does is say, look, in certain circumstances, we can raise the punishment a little bit higher. That's the engine that makes the act move. Yes, there is discussion in the act of a rebuttable presumption of not having to serve at least the mandatory minimum, but the heart and soul of the Drug-Free Zone Act is the enhanced punishment.
Let me go back to the waiver argument. I know you're out of time, but if the defendant didn't articulate to the point at which the trial court knew what to rule on, as far as the severability of the statute, constitutionality part, can we review that without findings being made in the lower court?
2 points on that, Your Honor. One, I think if this court is in the same position the trial court was, where it can't exactly figure out, if this court looks at the record below and is like, we're not exactly sure what was being asked for and why it was being asked for, then I think waiver is the most appropriate way forward. My second point would be, to some extent, this would be a lot of legal determinations. There wouldn't necessarily need to be findings from the trial court, so I don't know that this court's hands would necessarily be bound without factual findings from the trial court. But my main point is, if, as the trial court apparently thought, the defendant hasn't really explained what he wants and why he wants it, then this court should rule that the constitutional challenges are waived and then affirm the sentence under sort of the same sentencing scheme that this court is well familiar with. If there are no further questions, I ask that you affirm.
Thank you, Joe.
Thank you, Your Honor.
Now, opposing counsel has made the claim that Mr. Clanton was not sentenced under today's act, and I submit that if that's true, then that proves that there's error here, because the statute 39-17-432H says that he's supposed to be sentenced or resentenced under today's act. And so, that's a subtle admission right there. The state says that that if the new law is unconstitutional, then Mr. Clanton is just stuck with his old sentence. That's not correct, because under its statute 1-3-110, it says, it is hereby declared that the sections, clauses, sentences, and parts of the Tennessee Code are severable and are not matters of mutual essential inducement, and any of them shall be exscinded if the code would otherwise be unconstitutional or ineffective. And so it doesn't just mention parts, it doesn't just mention sections, it mentions sentences, it mentions even clauses. So individual parts can be struck down even if you're going to do an as a facial challenge to, strike down the law as to everyone. And that's before you even get to the more narrow question of, well, maybe the law is not unconstitutional facially, but it is unconstitutional as applied to this particular defendant, where you don't really have to strike down anything.
But did you articulate all that to the trial court? I mean, is all of that in the record? Was that before the trial court?
We specifically talked about, I believe, elision in the transcript, because the judge brought that up in the hearing during the oral argument. And the state has said that I've somehow waived this constitutional argument because the judge said that I didn't ask for any ruling
Well,
on
that's
the.
my question is, what did you actually ask for the judge to do with regard to your constitutional attack? I mean, what did you articulate as the constitutional attack, and what did you ask for a remedy?
Well, among other things, I mean, I didn't just argue one sentence, but on page 261 of the technical record, I specifically said, and since the enhancement provision is unconstitutional, Clanton may only be resentenced as a Class B felon. And that, again, it wasn't like a one-sentence argument, it's like a multiple.
I think Judge Ayers' question is, I can stand in front of the judge and say this is unconstitutional. What did you articulate to the judge as to why it is unconstitutional?
I cited, Giacco versus Pennsylvania, I cited Blakely versus Washington, most of the same cases that I've cited in my brief. So, I mean, it's the exact same argument. I've tried to make it even more intelligent as we've gone along and expand it, but it's the same argument. I did not waive anything. And I don't know why the judge even said that or exactly what he
So your argument
meant
is
by that.
it's unconstitutionally vague because it doesn't set out criteria.
Yes.
Is that it?
Yes, Your Honor. And further, the state has said that the judge did apply the principles of sentencing to give some sort of reason to enhance it to a Class A. The phrase principles of sentencing, I don't see that ever comes up in the judge's written order at all. So I don't think he did that. And moreover, he specifically said about 3 different times that that I'm right, that there are no principles by which he can either enhance it or not enhance it. He said, on page 274, he said, what can be problematic under the revised Drug-Free School Zone Act, as noted by the petitioner, when the jury finds or the defendant admits the offense happened within one of the places found in the code. What can be problematic is under what parameters should the court apply the enhancement to elevate the classification. And he says, presumably this would be subject to an abuse of discretion standard, but there are no parameters listed in the statute for the court to consider. And then he says petitioner alleges this could be done at the whims of the judge. And he ultimately never really addresses that, other than he does comment that the prior School Zone Act was specifically found not to be unconstitutionally vague. However, the prior School Zone Act didn't have this characteristic. It was a totally different issue. So just saying that the prior act wasn't unconstitutionally vague really has no bearing on anything.
So are you challenging the new act and the way the new act deals with this, or are you challenging subsection H?
I'm challenging not subsection H. I'm challenging, I think it's part of subsection B under the most recent version of 432.
Well, then I go back, I think, to what Judge Hickson was asking earlier. If we throw out the new part of B, that new part of the act, that subsection B, then you're back where you started.
I mean, I think the most sensible way to look at it is to say that I don't want to say that I'm not asking to throw out any part of the act, but I mean, the most practical way to deal with this would be to say it's an as-applied challenge and we don't have to throw out any part of the act. We just have to see whether the enhancement was unconstitutionally vague and violated due process as to this defendant. And I submit that it did for all the reasons I've articulated, and then you don't have to worry about throwing out anything. And beyond that, again, if the judge is specifically admitting that there's no principles, he's not claiming to have found by any principles that the sentence should be increased, so. For
I have
these,
one last question for you. So H says, though, that the burden is on you to show you would have gotten a lesser sentence.
correct.
How did you meet that burden?
We met that burden just by articulating all the facts that were
So-
introduced in the record, and I submit that
The fact that your crime was committed within 500 feet, which is under the new act, doesn't lessen your sentence. It wouldn't give you a lesser sentence. Now, if you'd been at 800 feet, you have an argument that, hey, under the new act, I wouldn't have been eligible for the up in classification. But at 500, you're within eligibility to be raised to classification, correct?
Here, what we said was, yes, that we were eligible to be raised, but that the raising was unconstitutional, and that in any event, there was no grounds listed in the statute by which to do it. And the judge basically agreed with that latter part. He disagreed that it was unconstitutional. So we would ask that the judgment be reversed. We would ask for either that the judgment be changed to 12 years at 30%, or else that it be remanded for the court to make that finding.
Thank you.
Thank you, counsel.
Anything further this morning? No, Your Honor. We will stand in recess until this afternoon.